Mr. Grassley asked you about legislative history and bearing down right hard on the issue of the committee reports. I've had the privilege of reading some of your writings, including a speech that you delivered between the fall of 1985 and spring 1986 at various law schools.
That was the speech,
Senator, on
right?
the use of the legislative history, not your dissent. And just to refresh your recollection, because I sort of agree with you on your priority that you give to the committee report. You quote from a Senate debate, floor debate on the tax bill in 1982, where Senator Armstrong and Senator Dole are involved in it, and Senator Armstrong points out the fallacies of what the committee report does, and involved in it just for everybody's edification. He said, he asked him, did any senator write the committee report? And Dole answered, I'd have to check. Does the senator know of any senator who wrote the committee report? He said he might be able to identify, but he'd have to search. And he said works, but it goes on to say staff. And he said, has the senator from Kansas, the chairman of the Finance Committee, read the committee report in its entirety? Senator Dole answers, I'm working on it. It's not a bestseller, but I'm working on it. And then he said, did the members of the Finance Committee vote on the committee report? Senator Dole says no. And Senator Armstrong says, Mr. President, the reason I raise the issue is not perhaps apparent on the surface. Let me just state this. The report itself was not considered by the Committee on Finance. It was not subject to amendment by the Committee on Finance. It's not subject to amendment now by the United States Senate. And you mentioned, and Senator Armstrong goes on and he says, for any jurist, administrative bureaucrat, tax practitioners, others who might chance upon the written record of this proceeding, let me just make the point that this is not the law. It was not voted on. It is not subject to amendment, and we should discipline ourselves to the task of expressing congressional intent in the statute. That's from the congressional record, July 19th, 1982. You state ironically, but understandably enough, this is in your speech, the more the courts have relied upon committee reports in recent years, the less reliable they have become. And then at the end of your speech, you state this, for the purpose, I suppose, I would rank most highly legislative history consisted of amendments defeated on the floor, where it appears clear that the reasons for the defeat was a rejection of a particular course, now said to be contained in the unamended text. I suppose next to that would be extended floor debate, at least in circumstances which occasionally occur where the final text is actually being crafted on the floor. And then you state at the bottom of my list, I would place what heretofore seems to have been placed at the top, the committee report. So I think you've expressed pretty well in your speech there the reason why the committee reports are not given a great deal of credence relative to legislative history.
I'm glad Senator Grassley's not here, though, Senator.
Well, maybe his staff will tell him, and I'll talk to him a little bit about it, but I thought that might be interesting to clarify and why. I think, frankly, that there has been too much reliance by congressional bodies on the committee report, and I've been one that's been arguing that is a wrong practice. Let me ask you this. In the Washington University Law Quarterly, you stated in an article entitled The Disease as Cure. This is a commentary on in order to get beyond racism, we must first take account of race. You state that I am in short opposed to racial affirmative action for reason of both principle and practicality. And you went on to say that I strongly favor what might be called, but for the coloration that the term has acquired in the context of its past use, affirmative action programs of many types of help for the poor and the disadvantaged. Judge, would you define what you meant by principle and practicality in the first quote, and what type of affirmative action programs you do favor?
Well, as to the latter, I think what I was saying is that there's, let me set it in context once again, Senator. This was not when I was a judge. It was a speech I gave. In fact, it was on a panel at which now Judge Edwards, who was then also an academic at the University of Michigan, was another one of the panelists, and it was a panel about affirmative action as a policy, not its constitutionality, not its legality, and I was speaking as a, in those days, a law professor who could have views on such policy matters. When I said I would favor certain types of affirmative action programs, I was referring to affirmative action programs in favor of the poor and disadvantaged, even when it turned out that every one of the poor people or every one of the disadvantaged people favored by a particular program turned out to be of a particular race. I said that would, of course, make no difference. But the basis for the affirmative action, the basis for the favoritism, was the poverty or the disadvantage. What I expressed myself in opposition to on policy grounds was favoring a group solely on racial or ethnic grounds and not on basis of poverty or disadvantage. As to the practical and principled problems I found with the latter type of affirmative action, one of the things I mentioned, I guess the two things are, number one, when you favor one person because of his race, you are automatically disfavoring another one because of his race. And I think the second consideration I pointed out was that to an extent it deprives the members of the race who are given the special advantage of the fruits of their labors, because they are sometimes regarded as having achieved those fruits only because of affirmative action, whereas they could have they could have made it without it, and there's no way that they can demonstrate that. Those are, as I say, policy views of mine at the time. I think they're views held by other reasonable people. They're views disagreed with by the Congress, and that's why one has a Congress. Those views have nothing to do with the way I will apply whatever affirmative action laws are enacted by the Congress.
In your questionnaire, you list your various positions and jobs, and you mention in quoting from your page 13 of your questionnaire, it says, in my final executive post as Assistant Attorney General for the Office of Legal Counsel, September 1974 to January 1977, I was legal advisor to the Attorney General, and through him or directly to the executive branch. The Office of Legal Counsel drafts the Attorney General's opinion and much more frequently issues its own opinions under the Attorney General's delegated authority to the White House and all executive agencies. The questions I dealt with were multifarious, covering all aspects of federal constitutional and statutory law. Then you say the job also involves a substantial amount of congressional testimony on such issues as executive privilege and the legislative veto. I just wonder if you recall any of the congressional testimony pertaining to executive privilege, to whom it was given in Congress, what the House or Senate and the committee, any time pertaining to that.
Senator, unless I'm mistaken, it was both before the Senate and the House. I think it was before Judiciary in both houses, but I'm sure I can get that for you. I'm sure it's all a matter of
You remember what
public...
the issue was about or how the circumstances arose?
I think mostly it was executive privilege in general. The whole doctrine of executive privilege was then at issue with regard to a number of different matters that the Congress had on the stove with the executive, and I don't recall right now any specific issue of executive privilege where it involved the withholding of any particular document or set of documents and where I was testifying. But I can get it for you. I'm sure there's a record of it. All that testimony is...
Well, I'm sure there's a record. I thought maybe you might give us enough to identify where we might look to see what you might have said pertaining to that at that particular time. You don't remember what the
I
issue
don't
was
remember.
that brought you to Congress?
No, at the time, Senator, I remember I think I was on a panel. I think it was a panel before a committee concerning whether there was any such thing. I mean, this was before the Supreme Court's decision in the United States versus Nixon. So there had been no court decision which, in so many words, had affirmed the existence of such an animal as executive privilege, and it was a matter of great interest to the Congress at that time. I was on a panel, as I recall, with Raoul Berger from Harvard, who was an opponent of the existence of any executive privilege.
Express the viewpoint that that cooperation with Congress should be followed, and that Congress should be allowed to see all documents except, and then list the exceptions that at the time had the president that you were serving under, who I assume was Ford, and were you also under Nixon as
No, I didn't serve under President Nixon. He was out of office before I was confirmed.
Well, did President Ford at that time issue any executive order which, in effect, described and limited the use of executive privilege?
Yes, Senator, but not in the manner you described. The way it was limited was not describing the subject matters, but rather describing the procedure for its assertion. And the procedure was a rigorous one. It could not ultimately be asserted by an executive officer without, as I recall, the approval of, I think it required the President's personal approval before it could be asserted. So it's a big deal. The executive branch does not take it lightly. Now, very often when an agency is asked for documents, it'll say, we're reluctant to turn them over, and there's a preliminary process of negotiation. But if it really comes down to hardcore, adamant positions on both sides that can't be resolved, before the agency can say, we will not comply with the subpoena for the documents, we will not turn them over, the procedures required that there be, as I recall it, approval by the President with the advice of the Attorney General on the matter. And as far as I know, I'm quite confident that that's still in effect, or something like it. We didn't take it lightly, Senator. I mean, it's always a
legal counsel whether or not he had issued an executive order which, in an effect, express the viewpoint that that cooperation with Congress should be followed, and that Congress should be allowed to see all documents except, and then list the exceptions that at the time had the president that you were serving under, who I assume was Ford, and were you also under Nixon as
No, I didn't serve under President Nixon. He was out of office before I was confirmed.
Well, did President Ford at that time issue any executive order which, in effect, described and limited the use of executive privilege?
Yes, Senator, but not in the manner you described. The way it was limited was not describing the subject matters, but rather describing the procedure for its assertion. And the procedure was a rigorous one. It could not ultimately be asserted by an executive officer without, as I recall, the approval of, I think it required the President's personal approval before it could be asserted. So it's a big deal. The executive branch does not take it lightly. Now, very often when an agency is asked for documents, it'll say, we're reluctant to turn them over, and there's a preliminary process of negotiation. But if it really comes down to hardcore, adamant positions on both sides that can't be resolved, before the agency can say, we will not comply with the subpoena for the documents, we will not turn them over, the procedures required that there be, as I recall it, approval by the President with the advice of the Attorney General on the matter. And as far as I know, I'm quite confident that that's still in effect, or something like it. We didn't take it lightly, Senator. I mean, it's always a regrettable confrontation between the two branches.